Senate Bill 1537. Imagine this. Imagine you get pulled into court as a witness, or you are the person accused and you do not speak English well. You are trying to follow what the judge says, what the lawyers ask, and what you are agreeing to. If the interpreter is not properly trained, one bad translation can change the whole outcome. What the bill says it does? Senate Bill 1537 says criminal courts must appoint an interpreter when someone involved in a criminal case cannot understand English, using the statewide interpreter standards already in Texas law. What it actually does? This means courts have to use licensed interpreters under the state's interpreter rules, instead of grabbing whoever is available. It also means some counties can no longer rely on cheaper, unlicensed interpreters, even if that was how they made it work before. Who benefits? Defendants and witnesses who need language help. Courts that want fewer appeals and mistrials caused by bad translation. Licensed interpreters, because the law favors qualified professionals, who pays the price. Smaller or rural counties that may face higher costs or longer waits to find a licensed interpreter. People in low supply languages if courts struggle to schedule qualified interpreters fast enough. Why it matters. If you cannot understand what is happening in court, you cannot defend yourself, and you cannot truly participate in the process. This bill pushes Texas toward fairness that should not depend on what county you are in. But if the state raises the standard without helping counties meet it, you can end up with delays, extra costs, and uneven access anyway, just in a different form. Bottom line, Senate Bill 1537 makes interpreter quality more consistent in criminal court, but Texas still has to make sure every county can actually afford and access that standard.